Welcome ladies and gentlemen to another episode of Legal Wrangle on GST. Today we will be presenting before you an analysis of some recent judgment pronounced by various high courts. Without much ado, let us proceed to the details of the first case. The SSC in this case is a dealer operating from Tamil Nadu. He had purchased some goods from a manufacturer in Delhi. On consigning the goods from Tamil Nadu, the SSC was transporting the goods to the state of Kerala. However, the goods were detained by the state GST officer Trivandrum. It was alleged that the SSC had misclassified the goods under heading 4601 taxable at the rate 18%, leading to short payment of tax. A detention notice was issued directing payment of CGST as well as SGST at the rate 14% each, as applicable to HSN Code 3926.
On hearing the SC, the High Court gave the following findings. Firstly, there is no doubt that the authorities appointed by the state have been empowered to implement the provisions of enactments which regulate the interstate as also the interstate trade. However, the specific power invoked in issuing the notice is under the CGST or the SGST, which is applicable only to the intra-state movement of goods. Secondly, admittedly the SSC had consigned the goods from Tamil Nadu and was transporting it to a third party at Pattambi. The third party submitted that they were ready to accept the consignment. The issue of misclassification and undervaluation has to be gone into by the respective assessing officers and not by the detaining officer. Thirdly, in such circumstances, the court is not inclined to permit further detention of the goods. The SSC shall be permitted release of the goods on the execution of simple bond without sureties as expeditiously as possible. The petition was allowed with the above observations. Now let's proceed to our next case.
Of the four petitioners in this case, two were dealers while the others two were transporters. The dealers purchased some goods from Delhi and the transporters were ferrying them to the destination in Uttar Pradesh. However, the goods were seized under section 129 of the UP GST Act 2017, as was the vehicle carrying them. The petitioner claimed that they had proper documentation such as invoices and e-way bills as evidence of the transaction. The petitioner also claimed that since the goods were being transported interstate, the IGST Act would be applicable law rather than UP GST Act. On such ground, the SSC claimed that the seizure of the goods was unlawful and unsustainable.
On the other hand, the revenue claimed that the e-way bills contained expired dates. Further, all goods being transported were backed by e-way bills. The revenue further pointed out irregularities regarding the quality of some of the goods. Thereby, the revenue proceeded to issue an SCN calculating value of those goods not backed with e-way bills. Such value was calculated at different rates as per individual item.
Finally, the High Court observed that in the instant case, since the factual disputed issues are involved and the penalty proceedings are already initiated, therefore, it would be proper in the interest of justice that the seized goods be released on the payment of the amount as indicated in the show cause notice. In the penalty order, a huge amount of more than Rs 6 lakhs has been fixed demanded against the petitioner, which in our opinion prima facie appears to be highly excessive. Since order of penalty is appealable before the first appellate authority, it would be in the interest of justice that the petitioner may approach the appellate authority and file an appeal against the penalty order. The goods and vehicle be released forthwith on payment of the amount of tax as has been indicated in the show cause notice. Hence, the issue at hand was settled partly in favor of the SSC. Let's now proceed to the final case. The present petition was filed seeking direction to the Department of Commercial Taxes of the state of Kerala to notify an authority for advance ruling as contemplated under section 96 of the Kerala State Goods and Services Tax Ordinance 2017. The petitioner claimed that although the statutory provisions contemplated setting up an authority for advance ruling within the state, the same were not put into effect. Consequently, the petitioner was unable to approach any authority for advance ruling. Moreover, the portal of the taxing authority did not provide for any method for filing applications before the authority for advance ruling.
On hearing the writ petition, the High Court observed that, firstly, the government pleader submitted that the authority for advance ruling had since been constituted by SRO number 638 of 2017, dated 21st of October 2017. It is pointed out that the Joint Commissioner of Central Tax, Central Excise and Customs, Thiruvananthapuram, as also the Joint Commissioner General State, Thiruvananthapuram, have been constituted as the members of the forum, which is the authority for advance ruling in the state. Secondly, as regards the apprehension of the petitioner with regard to filing procedures, it is clarified that till such time as the electronic filing system is put in place on the portal, the petitioner would be permitted to file their application manually before the said authority.
Thus, the writ petition was disposed of with such observation aligned with the apprehension of the petitioner. This brings us to the end of this episode. Thank you for watching this episode of Legal Wrangle on GST. Please stay tuned to TIOL Tube for more videos on issues relevant to the field of direct, indirect and corporate taxation. Please also feel free to share your views with us at editor@tiol.in. Have a good day.